Hello and welcome back to this course on critical learnings on forest and Adivasi rights. In this video, we will unravel how the laws of forest diversion and forest conservation are connected to the rights of forest dwelling population of India. Forest dwellers and the forests they live in have special protections under the Constitution. Diverting forest land for other purposes, therefore, has to be carefully administered. The Forest Conservation Act 1980 serves the constitutional duty of the state to protect our forests and our environment. In 2020, 367 proposals came before the central government under the Forest Conservation Act. These proposals sought its approval for diverting forest land for non-forest purposes. Section 2 of the Act places strict restrictions on the use of forest land for non-forest purposes, and Section 3 empowers the central government to constitute an advisory committee that has the duty to assess each project and grant approval or reject them. In 2020, the advisory committee considered projects requiring 14,855.91 hectares of forest land, out of which 63%, that is 9,434.06 hectares, was recommended for diversion. In 2022, the advisory committee considered projects requiring 14,855.91 hectares of forest land, out of which 63.5%, that is 9,434.06 hectares, was recommended for diversion. Only 3 out of these 367 proposals were rejected. Out of the approved projects, 57.97% were linear projects, which meant that more than half of these projects did not require consent from Gram Sabhas of the village that will be affected with their construction. While considering these figures for 2020, it is also important to note that the government had already recommended the diversion of 63,238.97 hectares of forest land between 2017 and 2019. 2021, which was a difficult year for public health around the world, was also a record-breaking year for forest and environmental clearances. From a low of 1,645 proposals in 2012 during the UPA government's final controversial years, the number now stands almost 3 times higher at 4,786 proposals. The number of clearances granted every year has been skyrocketing. The number hit a record of 2,328 clearances in 2020 and stood at 2,176 clearances in 2021. The spurt in forest clearances is also reflected in environment clearances under the Environment Impact Assessment Notification 2006 and wildlife clearances under the Wildlife Protection Act 1972. Wildlife clearances shows a big jump in 2021 as 99 projects were cleared. The curious thing about these diversions is that most of them happen without the consent of Gram Sabha, or for that matter, any recognition of the rights of the people who live and depend on these forest lands. The Environment Ministry has been trying to water down the provisions of forest diversion laws in order to undo the presence and significance of Gram Sabha, which is the constitutional village self-governance body. Simply because the Forest Rights Act does not use the word consent in its text, the idea that these diversions can legally happen without getting the Gram Sabha involved has been popularized by the state. We will see in this lecture just how incorrect these ideas are. The interpretation of law is not simply a matter of reading what is written in the text. Laws should be interpreted purposely in order to understand the objective and the aspirations of citizens. With a view to check deforestation, the Forest Conservation Act 1980 came into force. It aims to regulate the diversion of forest land for non-forest purposes, such as mining, hydropower, roads, railways, and other infrastructure. It overrode all existing laws. With its enactment, no state government or any other authority could make an order to divert forest land for such non-forest purposes without the prior approval of the central government. Non-forest purposes, according to the Act, means breaking or clearing from any forest land for the cultivation of crops such as tea, coffee, and rubber, or for any purposes other than re-afforestation. It also established an advisory committee to assess and grant approvals for such diversions. Therefore, the entire power of deciding the use of forest land became vested in the central government. The Supreme Court entered the debate on deforestation and forest land diversion with the Godavarman case in 1995. The court reinvented the principles of jurisdiction and issued a writ of continuous mandamus in order to take charge of deforestation in the country. However, the court's interference has done very little to change the state of affairs. Power shifted in 2006 with the enactment of the Forest Rights Act. Instead of taking a paternalistic outlook like that of the FCA and other forest laws, the Forest Rights Act recognized the rights, power, and the knowledge of forest communities and the significant role that they can play with state in conserving forests and the environment. One of the most fundamental principles enshrined in the Forest Rights Act is that the relationship of people with land and forests is determined by the twin ideas of autonomy and responsibility. Forest dwellers have the autonomy to decide about the use of forest land, and along with that, they also bear the responsibility to conserve and protect the forest from any form of degradation. Section 5 of the Act empowers the holders of forest rights and specifically the Gram Sabha to protect and preserve the forest and the wildlife and biodiversity it holds within. The responsibility for the preservation and conservation of the forest was given to the forest dwellers through their Gram Sabhas. They have the responsibility to ensure that their habitats are protected from any form of destructive practices. It also grants legitimacy to the governance of community forest resources, thereby reinforcing the collective power of Adivasi and other forest dwelling communities in the protection and conservation of forests. Very soon after the FRA came into force, it became clear that forest diversions could not continue as before, and that forest rights now needed to be accounted for. In July 2009, the Ministry of Environment, Forest and Climate Change issued a circular laying down the items for compliance of FRA while granting forest clearance. These, in brief, are as follows. First, that the rights recognition process must be complete. Second, that certification from district administration and the Gram Sabha is required. And third, that Gram Sabha must also, in a notification, consent to the diversion. In 2017, after a series of interventions made by the Ministry of Tribal Affairs and forest rights groups, an amendment was made to the Forest Conservation Rules 1980. This consolidates the Forest Rights Act and the Forest Conservation Act in a substantial way. Rule 6, Clause 3, Subclause E 1 and 2 clearly states that Gram Sabha's consent must be obtained by conducting the consent process under the Forest Rights Act. The proposal to divert forest land must indicate that this process is complete, and the district collector needs to finish this process in a time bound manner so that the in principle approval can be granted to the proposal as per Rule 6, Clause F. The first and possibly the most important example of the FCA FRA nexus is the Supreme Court's 2013 judgment in the Odisha Mining Corporation versus MOEF, popularly known as the Niyamgiri judgment. It set an important precedent with its emphasis on the centrality of the powers of Gram Sabha in safeguarding the community forest resource rights and the customary and religious rights of the forest dwellers under the FRA. The court reiterated that forests and forest dwellers are inextricably linked, and the forests have the best chance to survive when their safeguarding and conservation is done by these communities. The court held that the Gram Sabha of forest dwellers must play an integral role in the decision making process regarding whether their forests and forest resources can be diverted under the FCA for any non forest purposes. The Niyamgiri judgment engages with the spirit of FRA, implying that a crucial mode of exercising the forest dwelling community's rights to conserve is the Gram Sabha's will to give or withhold its consent for diversion of their forests for any kind of use. It is also important to remember that the Niyamgiri judgment coming from the Supreme Court is part of the law of the land itself. However, what happened after the judgment was revelatory. After all 12 Gram Sabhas denied the proposals for forest land diversions, Vedanta and the OMC went to the court on two different occasions and filed applications to get these consultations done again. The companies were putting pressure on the local communities to take back their decision and permit the mining. The court refused both times. The court was therefore able to protect forest land from getting diverted even after the local communities were being pressurized. If interpreted and implemented correctly, then the FCA and FRA can together conserve our forests. Another example showcasing the absurdity of forest land diversion in the country comes from Andaman and Nicobar Islands. They are home to 6 particularly vulnerable tribal groups. Since the 1950s, the Indian government has declared its concern for sustainable development in the islands. However, by 1993, the state's action had already led to clear felling of about 12% of Andaman's total land area. On 21st October 2019, the MOEF issued a notification that in case of forest diversion in states or union territories having more than 75% of forest coverage, the compensatory afforestation will be undertaken in other states, since forest land will be unavailable in the hosting state. This meant that dams and mining projects can be approved in the forest abundant Andamans and the northeastern states of the country, while their compensatory afforestation may be done on non-forest or degraded land in another state or union territory. The MOEF's decision prioritizes the ease of doing business in violation of Section 4, Clause 5 of the FRA and the provision on Gram Sabha consent for land diversion. Moreover, the biodiversity loss from such an approach to land diversion can be irreversible, as the forest ecosystem of the tropical islands cannot be reconstructed far away in the deciduous plateaus of mainland India. And yet, the Madhya Pradesh government has proceeded to identify 650 square kilometers of degraded forest land in MP for compensatory afforestation, in lieu of the land being diverted for commercial development and military projects in the islands. The island administration is denotifying wildlife sanctuaries and appropriating parts of the tribal reserves for this purpose, without undertaking the FRA claims verification process or seeking the consent of the forest dwellers who have sustained and depended on the forest ecosystem for centuries. The Forest Conservation Act is a law to conserve our forests, and it weaves an important role for the state to play in the process of conservation. This role is that of a protector, where the state can actually intervene and protect both the forests and the people who live in them. And in doing so, the forest dwellers, with their rights of FRA, are partners in the process of conservation. We have learnt in this video that the Forest Rights Act, in a sense, seeks to ensure that the autonomy of Adivasi and forest communities remains intact in all matters that affect them and their forests, and also that our forests remain protected and deforestation be kept to the minimum. The Forest Conservation Act becomes significant in matters of diversion of forest land for non-forest purposes. The FCA, read along with the FRA, grants enormous responsibility to the state to check deforestation and protect the rights of the people who live in these forests. The next video will take this argument further to the realm of mining laws. Thank you for watching.